Overview of remedies, California. In brief, always look for the available remedies in this order: damages, money stemming from tort or breach of contract; restitution, money stemming from unjust enrichment; injunction, equitable order to refrain from doing something; negative injunction, or to do something; mandatory or affirmative injunction. In contrast, this is usually specific performance decree. So look in that order: damages, restitution, and injunction. Types of damages. Compensatory damages compensate the plaintiff for loss or injury. General damage is compensate foreseeable losses, and special damages compensate unforeseeable losses and must be specifically pleaded. Nominal damages are often recoverable when no actual injury is sustained. Punitive damages must be awarded to punish a defendant for willful, wanton, or malicious conduct. Interest and attorney's fees. Awards of prejudgment interest are usually statutory. Attorney's fees are generally not recoverable absent a statute or contract. Restitutionary damages. Restitutionary damages obligate the defendant to pay the plaintiff the reasonable value of a benefit unjustly obtained. This can take the form of an action in quasi-contract. Replevin permits plaintiff to recover before trial possession of specific chattel wrongfully taken or detained. Ejectment is a legal remedy to restore possession of real property from which plaintiff was wrongfully ousted. So those are some special restitutionary remedies. I'm going to go backwards, just saying compensatory damages compensate the plaintiff for loss of injury. There's general, special. General are obviously foreseeable losses, whereas special are for unforeseeable losses and must be specifically pleaded generally. The parties knew about them. And interest in attorney's fees is relevant because by interest in becoming an attorney, you'll want to know attorney's fees are generally not recoverable absent a statute or contract. And awards of prejudgment interest are usually statutory. So a couple special restitutionary remedies. Replevin permits a plaintiff to recover before trial possession of specific chattel wrongfully taken or detained, and ejectment is a legal remedy to restore possession of real property from which plaintiff was wrongfully ousted. Restitutionary damages obligate the defendant to pay the plaintiff the reasonable value of a benefit unjustly obtained. This can take the form of an action in quasi-contract. Constructive trust. Equity creates trust to compel defendant to reconvey title to property unjustly retained, whereas an equitable lien is a lien imposed on the defendant's property to secure payment of a debt owed to plaintiff. So constructive trust. Equity creates a trust to compel the defendant to reconvey title to property unjustly retained, whereas equitable liens a lien imposed on the defendant's property to secure payment of a debt owed to the plaintiff. Injunctive relief in tort may be granted if the legal remedy is inadequate, money damages will not make the plaintiff whole, and damages are highly speculative. The decree can be enforced. That's the second prerequisite. Feasibility of enforceability. Third, the hardship to the defendant or the public does not outweigh the benefit to the plaintiff. Fourth, there are no defenses such as laches, unclean hands, and freedom of speech as a defense to defamation. For laches, the plaintiff has unreasonably delayed asserting an equitable claim, and the delay has resulted in prejudice to the defendant. Unclean hands, the plaintiff is guilty of inequitable or wrongful conduct with respect to the transaction at issue. Interlocutory injunctions are used to preserve the status quo until a trial on the merits can be held, and requires a showing of likelihood of prevailing on the merits that absent interlocutory injunction, irreparable injury will result before trial can be held. Subpart D, application of remedies to specific tort cases. Misappropriation of money. To recover money damages, the plaintiff may bring an action for conversion B, restitutionary remedies. A quasi-contract remedy, an alternative to tort, is an equitable remedy imposed by courts to avoid unjust enrichment by ordering that the value of an unjustly obtained benefit be transferred to the plaintiff. The plaintiff need only show the defendant was unjustly enriched and the plaintiff is justly entitled to the benefit. Constructive trust. The stolen property must be specifically identified and traced to the possession of the wrongdoer. So constructive trust, we talked about it before. It is in tort action, it's a remedy for misappropriation of money. Next page 3 of 10, equitable lien used in tort, again, for the misappropriation of money. If a constructive trust cannot be imposed because title was not acquired with the stolen property, but the misappropriated money can be traced to an improvement on property, an equitable lien may be imposed on the property. Remedies for injuries in to personal property. In the destruction of chattels, the plaintiff may recover the value of the chattel at the time of destruction, less salvage plus interest. Injury to chattels. So I'm going to say destruction of chattels is what's going to follow a conversion, where the plaintiff, because the chattel is destroyed. So the plaintiff's going to recover the value of the chattel at the time of destruction, less salvage plus interest. For injury to chattels, the plaintiff may recover either the diminution in value to the chattel or the cost of repair. Dispossession of chattels. Conversion damages is a remedy only if the dispossession causes substantial interference with the plaintiff's ownership rights. Damages are measured at the market value of the property at the time of the conversion plus interest. Plaintiff may recover fair compensation for time and monies properly expended in pursuit of the property, which can be substantial if you're talking about like art lost after World War II. Alternatively, the plaintiff may seek restitutionary remedies, including self-help, replevin, quasi-contract, constructive trust, and equitable lien. Remedies, so that's the suing and assumptive, I think, would be the quasi-contract. So you've used my device, and since you haven't quite harmed it, I'm going to say that you rented it from me so that I can recover for your trespass to my chattel. Constructive trust and equitable lien might be the same. Maybe that device was used to improve your property. And equitable lien, I can't imagine when a constructive trust would help for dispossession of chattel, unless you took title to it by false pretenses, not larceny by trick. Both of those are crimes and not actually torts. So I'm still not certain when a constructive trust would follow dispossession of chattel. Unless we're talking cars, I still don't understand. Remedies for injuries to real property, trespass to land. No. So now we're talking real property has been injured by trespass. In tort, what are the remedies? 1, no physical injury results to the realty from a simple trespass, but the plaintiff may recover nominal damages. 2, trespass causing severance, like you've removed my corn. You can get damages, restitutionary remedies, and injunctive relief. For trespasses causing other injury, there's damages and injunctive relief. You've cut down all my trees. Trespass affecting ouster, ejectment, mezzanine damages, which is the rental value for the period the land is occupied by the trespasser. We talked about ejectment earlier. Encroachment damages, injectment, and injunction for an encroachment. So you've got to restore my land by removing your flower garden. You need to remove it and leave the area, and you may not use it again forever. Destruction of or injury to realty. Remedy is the difference between the value of the land before and after the injury. So what was that? Destruction of or injury to realty. Remedy is the difference between the value of the land before and after the injury. Destruction of or interference with easements, damages, and injunctive relief. Are available for the destruction of or interference with easements. Waste, damages, and injunctive relief. That's like ameliorative waste, permissive waste, and maybe impermissive waste. Nuisance, damages, and injunctive relief are available for nuisance cases. Remedies for injuries to personal interests. Personal injuries is the first section. Survival of tort action, defamation, privacy. So I'm going to go through the shortest first and return back to the top. For privacy, damages and injunctive relief are available. For defamation, no restitutionary remedies and generally no injunctive relief. Courts don't really like defamation cases. Survival of tort actions is 1, based on statute, and 2, damages accrue to the decedent up to the time of death. But for personal injuries, you'll have no restitutionary remedies, and injunctive relief is rarely sought. For the monetary damages, you'll have economic and non-economic losses. Economic losses are special damages, including medical expenses and loss of earnings past and future. Non-economic losses are general damages, including pain and suffering, emotional anguish, and loss of enjoyment of life. Fraud. In fraud tort actions, the plaintiff must prove actual injury. Consequential damages may also be recovered. Punitive damages are recoverable if malice is shown. And remedies include damages, rescission, and constructive trust. So the plaintiff must prove the actual injury. Consequential damages may be recovered. Punitive damages on top of the actual injury. Punitive damages are recoverable if malice is shown, and remedies include damages, rescissions, and constructive trust. If you think, why would fraud ever come up in tort, as I've learned it, I'm assuming fraudulent misrepresentation, probably coupled with contract. And we're not the business torts, because I'm going into business torts right now, but maybe. If you're talking like a sole prop, I don't really know. But inducing breach of contract remedies include damages, restitutionary remedies, and injunctive relief. So that would probably be your interference with an existing contract, which includes breach of contract remedies, including damages, restitutionary remedies, and injunctive relief, whereas an interference with prospective advantage is where the plaintiff has been deprived of an expectancy, but not of an actual property or property right, and damages may be unavailable because they are uncertain. Although loss from an expectancy right may be uncertain, if the defendant's conduct provided him a benefit, the plaintiff may compel the defendant to turn over that benefit. Trade libel, special damages must be pleaded, and majority of courts will grant injunctive relief if trade libel occurs in conjunction with other enjoinable torts. Contract remedies, which is a wholly different section than torts, which I just finished up. The types of damages under contract remedies are compensatory damages that put the plaintiff in as good a position as if the defendant had performed the contract. Punitive damages are generally not recoverable in contract actions. Prejudgment interest is available as a matter of law if the claim is for a sum certain and it is discretionary on other claims. Attorney's fees generally may not be awarded unless provided by statute. So the types of damages, they have them bucketed into compensatory and punitive, and then they talk about prejudgment interest and attorney's fees. So restitutionary subpart B must be a subpart of compensatory damages, okay? And specific performance, rescission, reformation, those are all equitable remedies. Application of remedies to particular types of contracts. All right, we'll get into that last. So I'm going back to the fact that they've decided there's 3 types of remedies for under contract law, types of damages under contract law: compensatory, punitive, prejudgment interest, attorney fees. May not be awarded unless provided by statute. But prejudgment interest is available as a matter of law if the claim is for some certain and is discretionary on other claims. Now, I don't know why they don't have a section for equitable remedies. I guess they're assuming that the equitable remedies and restitution are part of compensatory damages. So let's go on. In fact, I think restitution remedy is just saying dash quasi-contract right here is an equitable remedy itself. So grounds for the remedy. The most common situations for unjust enrichment may be found when the defendant has received benefits by mistake, A. B. Prior to a material breach of contract, C. Pursuant to performance of an enforceable contract. Material breach of contract. Where a contract has been materially breached by one party, the other party has a right to restitution of the benefit conferred. Generally, the plaintiff is entitled to recover the value of performance. So the benefits are either by mistake, prior to a material breach, or pursuant to performance of an unenforceable contract. A material breach of contract is just a whole another restitutionary remedy. That's why it didn't seem like it fit to me. For material breach of contracts, the restitutionary remedies would be A, where a contract has been materially breached by one party, the other party has a right to restitution of the benefit conferred. Generally, the plaintiff is entitled to recover the value of performance. Unenforceable contracts. The restitutionary recovery depends on the nature of the benefit conferred. If tangible property has been transferred, specific restitution is an appropriate remedy. If services have been performed or materials furnished, generally recovery is measured by the value of the goods and services. So I have to read that a second time again too, because I'm just incessantly only halfway paying attention to what I'm reading. So circumstances, environmental circumstances. For unenforceable contracts, your restitutionary remedies depend on the nature of the benefit conferred. If tangible property has been transferred, specific restitution is an appropriate remedy. If services have been performed or materials furnished, generally recovery is measured by the value of the goods and services. Specific performance, another equitable remedy. I don't know if it fits into compensatory or if it fits into punitive, not punitive, and if it fits into prejudgment interest or attorney. So it must be compensatory if there's only 3 types of contract remedies. It has 5 parts. There must be a valid contract between the parties. Generally, the plaintiff will not be able to obtain specific performance unless she has fulfilled all the contract's conditions or is ready and able to perform. A legal remedy must be inadequate, enforcement must be feasible, and the defendant must not have any viable defenses, including laches, unclean hands, hardship, mistake, and misrepresentation. I think cha-cha is real hard or difficult. I think that's I'm trying to think of the mnemonic. So cha would be the valid contract. Cha would be the conditions are performed, or the plaintiff's ready to perform. Cha is inadequate remedy, fairly, feasibility of enforcement, difficult, no defenses. So cha is fairly difficult. Contract, condition, inadequacy, feasibility, defenses. Rescission. So for rescission and reformation, the mnemonic is very good dog and good dog. So which one's which? For rescission, this restores the plaintiff to the status quo before the contract. The grounds for rescission must have occurred at or before the time the contract was entered. By mutual mistake, unilateral mistake, and misrepresentation. So So for rescission, to rescind a contract, you need to have a valid contract, which is why it's a very good dog. V, valid contract, and very good dog is, grounds for the rescission, which is mutual mistake, unilateral mistake, or misrepresentation. And dog would be the absence of defenses, such as latches and unclean hands, other remedies. It says here, election of remedies prevents the plaintiff from seeking damages for fraud and then seeking rescission based on the fraud because the two remedies are inconsistent. Under Article 2 of the UCC, the plaintiff may seek rescission and damages in the alternative, and a plaintiff may be stopped from pursuing rescission if the contract is affirmed after facts justifying rescission are known, and cancellation of written instrument may be affected where it is void or voidable to the person seeking cancellation, and there is reasonable apprehension that if the instrument is left outstanding, it may cause serious injury. So all of that must be your defenses. The absence thereof is the only way you're going to recover for rescission of a valid contract, right, with grounds for rescission, including mutual mistake, unilateral mistake, and misrepresentation, without defenses such as latches, unclean hands, election of remedies, estoppel, and maybe the parties canceled, voided contract. Reformation. A court modifies or alters a written instrument to make it conform to the parties' previous understanding or agreement. There must be a valid original contract. So reformation is very good dog, whereas rescission apparently is just good dog. Right? So for this one, you need to have a valid original contract for a reformation. Grounds for the reformation are the same: mistake of fact, mutual or unilateral mistake of law, and fraud, which is something more than misrepresentation. And the lack of defenses, which is latches or bonus sale to a bona fide purchaser, and interlocutory injunctions are available, such as tort actions. So now subpart F, the last section, is how does this apply to particular types of contracts, such as those to buy and sell personal property, damages, and specific performance are available if the chattel is unique or damages are highly speculative. Damages to buy and sell real property. Contracts to buy and sell real property can be remedied by damages, restitution, specific performance, or partial performance with abatement in some cases if full performance cannot be completed, and defenses. The statute of frauds is the most common defense, but part performance doctrine may take the contract out of the statute. Equitable conversion. A buyer is considered the equitable owner when the contract is executed and the seller is considered to have only the right to money. Construction contracts is the third type of contract with special considerations here. Personal service contracts. I'm sure employment's in here somewhere unless I already read it. I don't think it did. So for Construction contracts, damages when the owner breaches are 1, 2, and 3-fold. If the contract is wholly executory, damages are measured by the builder's lost profits. 2, if the contract is fully performed, damages are the contract price plus interest. And 3rd, if the contract is partially performed, damages are measured by deducting from the contract price the cost of completing the contract, or by deducting from the contract price the total cost of performance and adding the cost of partial performance. That's when the owner breaches. So I'm going to read that one more time because it didn't make sense initially. You could have, for a fully performed contract, price plus interest. For a partially performed construction contract, you deduct from the full price, full contract value, you deduct the cost of completing the contract, or by deducting from the contract price the total cost of performance and adding the cost of partial performance, which I still don't think makes any sense. So I have to look at an alternate way that was written. Damages in the builder breaches is if the builder has substantially performed, damages are the cost of repair or replacement to meet contract specifications, or the difference in the building's value as built and the value had it been constructed by the per the contract specifications. If the builder has abandoned the contract and is in material breach, damages are measured by what the owner must pay to have the construction completed, less anything owed the builder, not true, plus compensation for delay. So that right there, MBE doesn't believe what they just said. So you're not going to just deduct less anything owed the builder right now, because it's going to have to come as like a cross complaint. So you're not going to just answer that the value to finish the building and the compensation, the delay, minus what you owe to the builder. You're not going to do that. The builder has to bring their suit, especially if they materially breached rather than minor breach. So this might be how it happens in real life, but the MBE is going to say that's the wrong answer. If you're trying to just say, well, it cost you $50,000 to finish the project and the builder spent $50,000, so nobody recovers at all. That's not going to just wash like that. Restitutionary remedies. Where the owner repudiates the contract after partial performance, the builder may elect to rescind the contract and sue in quasi-contract for the value of the benefit conferred, even if that is above the contract price. Where the builder has materially breached the contract, courts generally permit restitution. So back to this restitutionary remedies in the construction contract, or the builder breaches, where the owner repudiates. Okay, that's different. We're outside of the builder breach and the owner breach. So here, the owners repudiated the contract after partial performance. The builder may elect to rescind the contract and sue in quasi-contract for the value of the benefit conferred, even if that is above the contract price. Where the builder has materially breached the contract, courts generally permit restitution. And specific performance, modern courts will decree specific performance when there is no adequate remedy at law. One thing they're not saying here is that on repudiation, the builder has to stop building to mitigate damages. Personal service contracts, a whole new contract damages section. Damages when an employee breaches. Damages is the cost of obtained services equivalent to those promised. 2, when an employer breaches, damages is the total wages due or promised less the amount earned or that would have been earned. Employer must prove suitable work was available in the locale. So that's the employer breach, total wages due or promised less amount earned or could have been earned. When an employee breaches, it's the cost of obtained services equivalent to those promised by the employee. Restitution those are money damages, but restitutionary damages, when an employer breaches, the employee may elect a restitutionary remedy and sue for the reasonable value of the services rendered. Like for instance, you had been hired to do one project, payment at the end, fulfillment of that one project, and you were dismissed before it was completed. You may elect a restitutionary remedy and sue for the reasonable value of the services that you actually rendered. Where an employee breaches, the employer may rescind and seek restitution of wages paid but not earned. If you paid for that project at the beginning and they walked off the job. An employee who materially breaches may be able to recover the value of the benefit conferred, subject to an offset for the employer's damages. An employee who materially breaches may be able to recover the value of the benefit conferred, subject to an offset for the employer's damages. So maybe, I don't even know how to explain an example of that. Specific performance. If the services are unique, the legal remedy would be inadequate, but a court will nevertheless refuse to grant specific performance because it's not feasible to enforce a professional service or a personal service to be performed, because it would implicate the involuntary servitude Amendment 13 and would be hard to supervise, because more likely than not, they would not be giving you the type of performance that you bargained for. Equity may specifically enforce an employee's promise not to work for anyone else during the term of the employment. However, this would be a negative covenant. Those are upheld in equity, and they would enjoin the employee from accepting other employment during the time that the performing party had contracted to perform under the contract that was breached. Covenants not to compete. Equity will enjoin a breach of covenant not to compete, provided the services are unique and the restriction is reasonable as to the geographic scope and duration.